Away from that interview, COVID-19 has got many people talking. Following the directive from the government stopping large gatherings and the need to practice social distancing, the courts across the country have also put in place measures to check the spread of the coronavirus. Some senior lawyers who spoke to Law Weekly spoke on some of the measures put in place so far.
If you look at the nature of this, I don't know whether to call it an epidemic or what now. If you look at the nature of it, it's so scary. It's so very scary that no matter what precautions you think you have taken, just by standing beside somebody who has it and he sees it or he coughs, you may just get it. And you may not even know that you've gotten it because it has some number of time to gestate and all of that. So even when you are walking around thinking you are okay, you may not be okay. And then you take that back home to your family and all of that. Everybody gets there's a problem here. There's a problem here. And so if government, it's not a question that government is panicking or anything, no. It's one of the constitutional duties of government is to secure the citizens. Not just in terms of against Boko Haram or bandits and all that. Even health issues. They have to deal with security. So if government thinks they need to do more than they are doing now, we should all support them. We should. Look at what has happened in China from what I heard. They were able to keep everybody indoors. I don't know whether it is true. I heard they gave them money to stock up and they stay indoors. And it appears they are containing to a large extent. And that's where it started from. So it means if we stay indoors for a while, it can work. If we are lethargic about this, we may be only a few. Just last week we were saying, oh, we have only one or two cases. Now, yesterday, they're telling us it's going to about 10 cases. Before you know it, that's where it's escalated in England and in America. They were joking with it, oh, we have only one. Before they knew it, overnight, 1,000, 10,000. And it has become a problem. So nothing is too much. If they feel at some point that the court should be shut down, so let it be.
The issue of life should be taken more seriously by the government. The concept of social distancing is something we should explore to ensure that anywhere where people could gather, for now, we'll try and place sufficient restrictions and put measures in place. Just having a single check at the entrance of the court is not sufficient in my understanding. There ought to be sanitizers at the entrance of the courts. Given what we now know about the virus, even where it's on metal, on doorposts, on any surface, it could remain there for hours. And so in places like the courts where people gather together, it is important to take more measures in detail. There are courts where you have up to 20, 30 people, and it's not even the number actually, but that for now we ought to play safe. So it's good to explore the possibility. We're almost at the Easter vacation, so I think that it will be reasonable for the courts to consider the option of asking lawyers and litigants to stay at home, except for urgent cases that may involve life. Then you can have some judges that can be on vacation and they can schedule those cases to hear them one after the other, not at a time. You give time, 11 o'clock, you come by 10, you come by 9, so you don't have more than 3 or 4 people in a courtroom at a particular time. But I think it's important to take measures to safeguard lives of litigants, lawyers, and all those who come to the courtroom.
Yeah, well, so far so good. The important is to start. There's a temperature detector. It will show whether you are normal or abnormal. Once the temperature goes beyond certain level, it shows something is wrong with you. It does not necessarily mean that you are infected. It could be that you have other ailments. So the best thing is to isolate you, and then you know that you have something to treat. That's a starting point.
Now, the ECOWAS court sitting in Abuja, the FCT, has ordered the suspension of all its court sessions from Monday, the 23rd of March. The president of the court says hearing notices will be served on parties when the situation improves. In Ogun State, the Honorable Chief Judge, Honorable Justice Dikolu, has directed that only urgent and criminal matters will be attended to at the High Court, while only fresh criminal overnight cases and custody cases will be attended to at the magistrate courts until further notice. The CJ also says that only parties to such cases will be allowed into the court premises at this period. Now, talking about the courts, let's bring you a recap of some of the cases that we've been tracking.
We begin with the report that the Supreme Court has reserved judgment in the hearing of the All Progressives Congress APC's application seeking the review of its judgment on the Zamfara elections. The Chief Justice of Nigeria, Justice Tanko Mohammed, who led a 5-man panel, announced that the judgment date will be communicated to all the parties. On July the 22nd, 2019, the Supreme Court had struck out the APC's application asking it to review its May 24th judgment on the governorship election in Zamfara State. From the Supreme Court, we move to the Court of Appeal, which has set aside an FCT High Court judgment sacking Senator Ifeanyi Ubah as a lawmaker representing Anambra South Senatorial District. In a unanimous judgment delivered by Justice Stephen Ada, the court held that the FCT High Court acted outside its jurisdiction to entertain a matter that arose in Anambra State. Justice Ada, while awarding a cost of 250,000 naira against the first and second respondent in their appeal, insisted the lower court acted like an octopus and denied Senator Ubah the right to a fair hearing. On January 18, Senator Ifeanyi Ubah had filed a suit at the Court of Appeal challenging the judgment, which removed him as a lawmaker representing the district. Still at the Court of Appeal, a 3-man panel of the court presided over by Justice Abubakar Yahaya has ordered a stay of execution of the order of the FCT High Court suspending Adams Oshomole. The court's order subsists pending the hearing and determination of the motion on notice filed by the APC national chairman. The court also granted an order of interim injunction restraining the defendants from taking any action that would violate the order of a stay of execution granted by the court. The Court of Appeal warned political parties to resolve their differences amicably without resorting to the court. From the appeal court, we move to the Federal High Court sitting in Lagos, which has adjourned the trial of a former Speaker of the Lagos State House of Assembly, Adeyemi Ikufo-Oriji, to September 30. Honorable Ikufo-Oriji is currently standing trial on allegations of laundering 338.8 million naira. He is facing trial alongside his former personal assistant, Oyebode Atoyebi, on 54 counts. They, however, pleaded not guilty before Justice Mohammed Liman and were allowed to continue on the bail terms earlier granted them by the previous trial judge. Without coming out of his chambers, Justice Mohammed Liman ordered the court registrar to tell the parties in the case that in view of the directive of the chief judge that new trials should not be opened, especially because of the impending transfer of judges, the case is adjourned till after vacation. The registrar then announced September 30 as the new adjourned date. Counsel to the Economic and Financial Crimes Commission, Ekene Ihanacho, immediately raised a complaint saying the annual vacation is expected to start in July and the court could give any date before then, but the registrar insisted that this was a directive of the judge. The transfer of this case by Justice Liman appears to clearly contravene the provisions of Section 396, subsection 3 and 4 of the Administration of Criminal Justice Act, which says upon arraignment, the trial of a defendant shall proceed from day to day, and where applicable, no party shall be entitled to an adjournment which shall not exceed 14 working days. And we round off with the report that a senior advocate of Nigeria, Femi Falana, has written to the Chief Coroner of Lagos State, Justice Mojisola Jada, seeking an inquest into the Abule Ado explosion of Sunday, March 15, which led to an inferno, killing 17 people and destroying about 50 houses. He says reports indicate that the Nigerian National Petroleum Corporation (NNPC) has blamed the inferno on gas explosion, which occurred after a truck hit some gas cylinders stacked in a gas processing plant located near the corporation's System 2B pipeline right-of-way. He also says that it's been confirmed that the resulting fire later spread to the NNPC oil pipeline passing through the area, which aggravated the explosion. It is because of this that he wants the Chief Coroner to use our good office to cause a coroner's inquest to be conducted into the cause of the said explosion and make appropriate recommendations pursuant to Section 15 of the Lagos State Coroner's Law 2007, which provides that an inquest shall hold whenever a coroner is informed that the death of a deceased person within his district was the result of death in a violent, unnatural, or suspicious situation.
And that's the program this week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Sheeli. Thank you for watching.